Good afternoon, everyone. Good afternoon, everyone. My name is Hadar Harris. I'm the Executive Director of the Center for Human Rights and Humanitarian Law, and I will tell you, we ordered cookies for 40 people thinking we were taking some home. What this has proven to me is we are only now ever going to plan events 36 hours in advance. We are thrilled to see so many people here. The room 603, our largest room at the law school, is packed to standing room only. And we know that there are people watching on live webcast around the world. Indeed, I received some emails today from people who had set alarm clocks in Kabul, Afghanistan, to wake up and be with us tonight. And so we want to say hello to you and thank you for joining us, and to our speakers and to our panel who at very short notice agreed that it was very important for us to have this discussion today. As we speak right now, confirmation hearings are taking place in the U.S. Senate for John Brennan as the nominated director of the Central Intelligence Agency. Clearly, the discussion that we are having or about to have is probably going to be a little different than the one that they're having on the Senate, although I suspect that the senators would like to hear what it is that we're about to say from Mr. Brennan. I don't want to say much more other than we are grateful for all of you coming. We are grateful to our panelists, and I am going to turn it over to Professor Amanda Frost, who will be moderating today's event. Thank you.
Welcome to all the people physically present and those who are listening virtually. Good afternoon to those here. Good morning to some. As the moderator, I'm going to be the person who speaks the least, and my role is going to be to quickly set the scene for the discussion to follow, and then very briefly introduce our speakers. So, as probably most of you know, President Bush instituted a program of targeted assassination of suspected terrorists through the use of drones, which are unmanned aerial vehicles. And President Obama has continued the use of these drones, and in fact, it appears that he has increased their use greatly. It's estimated, there's no confirmation of this, but it's estimated that between 3,000 and 4,500 people have been killed by these drone strikes. Some of these people are, of course, the intended targets of the strikes. Many are bystanders. In September of 2011, the U.S. used a drone to kill Anwar al-Awlaki, am I saying his name right? Awlaki, an American citizen living in Yemen who is a member of al-Qaeda. And, of course, the killing of a U.S. citizen through these drone strikes raised much concern and many questions about whether international law and domestic law, particularly U.S. constitutional law, was being violated. There have been calls by many, including members of Congress, for the administration to release its justification for the use of these drones and to explain the legal basis and the analysis that it goes through before it uses drone strikes to kill anyone, but in particular American citizens abroad. That brings us to Monday, when, as many of you know, a white paper by the Department of Justice was leaked. In this paper, it's a 16-page memo, the Department of Justice laid out the case for using drone strikes to kill American citizens, and the paper itself is very controversial, as folks on the panel will explain in more detail. There were further calls for release of additional information about the administration's process for using drones, in particular to kill American citizens. And on Wednesday, the administration finally agreed to release more of its analysis. It's not clear it's releasing all of the document, but there's a 2010 memo by the Office of Legal Counsel that lays out in greater detail the justification and the process by which these drone strikes take place. All of this is in conjunction with the testimony of John Brennan, who I think as we speak is testifying before the Senate Intelligence Committee in the course of his confirmation hearings for the position of the Director of CIA. So we have here a very distinguished panel. I will not describe their bios in detail. If you care to feel depressed about your own accomplishments, you can go and look at their web pages. I have next to me Steve Vladeck, who is Professor of Constitutional Law, and he will describe the national security law implications and the overall constitutional implications of the policies outlined in DOJ's memo. Next to Steve, we have Bob Goldman, a professor here as well, who can speak about the international humanitarian law implications of the drone program. Next to Bob, we have Hadar Harris, Executive Director of the Center for Human Rights and Humanitarian Law, who will discuss human rights standards and also talk about, through a comparative perspective, the Israeli program of targeted killings. And then we have Dan Marcus at the end, Fellow in Law and Government and former counsel for the 9/11 Commission, who will talk about the policy implications as well as the Brennan confirmation hearings to the degree we know anything about them at this point. So let's give our panel a round of applause, and then we'll turn to Steve.
Great. Thank you, Amanda. Thanks, everybody, for coming. It's quite a turnout. So let me just sort of briefly set the stage for the discussion. As Amanda mentioned, I'm going to talk about the U.S. law side of this. Bob's going to talk about the international humanitarian law side of it, and Hadar's going to do the human rights law. And these are the three sort of dominant bodies of law that are or might be relevant to this conversation. U.S. law insofar as it constrains the government's authority and or confers rights upon the targets of these operations. IHL insofar as it provides the rules that apply in an armed conflict. Human rights law insofar as it constrains the power of governments to act against their citizens or others. So with regard to U.S. law, first, I think one slight correction from what Amanda said. I mean, so the underlying OLC memo, which everyone knows exists and no one confirms exists, still actually hasn't been disclosed to anybody except the members of the Congressional Intelligence Committee. So we actually still don't know what we don't know, which is actually pretty important because the white paper is no memo on this front. And so let me elaborate. So the critical things to know about the U.S. law issue. Congress on September 18, 2001, in a statute called the Authorization for the Use of Military Force, the AUMF, authorized the President to use all necessary and appropriate force against those persons he determines planned, perpetrated, committed, or are otherwise involved with supporting those groups responsible for 9/11. So we didn't actually go to war with terrorism on September 18, 2001. We went to war with al-Qaeda and its affiliates. And indeed, there's actually a surprisingly rich body of case law, both in the U.S., on the U.S. sort of domestic side and vis-a-vis Guantanamo, giving content to just what the government can do, who is a member of al-Qaeda, who can be detained, and so by implication, who can be targeted. And so that's sort of the first threshold point. The government's authority to conduct these kinds of strikes comes from this statute and from the idea that we have the power to use military force against al-Qaeda. Now, the juxtaposition, the most important thing to keep in mind, the reason why U.S. citizens have become such an important flashpoint legally is the due process clause of the Fifth Amendment. So it's actually fairly well settled, although not without controversy, that non-citizens outside the United States are not protected by the due process clause. And so whatever rules international law may prescribe in the context of military operations against non-citizens outside the U.S., the Constitution has very little to say about it, so long as the government's actions are authorized. But citizens are a different ballgame. U.S. citizens these days, although it wasn't always so, are protected by the due process clause just about wherever they go, and just about whatever they do. And that's why the Al-Awlaki case has been so problematic, so controversial on this front. So the due process clause imposes both substantive and procedural limits on the government. Substantively, it means the government always has to have a sufficiently good reason for what it's doing. So in this context, the government has to have a sufficiently compelling justification for using military force against its own. But procedurally, I mean, that may be even the more important piece of this puzzle. Procedurally, the due process clause requires that the government actually engage in process. Process that is both fair and predictable, and process that is designed to minimize false positives, to actually ensure that the government is being as precise as it can be in this context. And that's where this, the white paper and the OLC memo have been such a point of controversy. In a speech he gave last March at Northwestern University Law School, Attorney General Holder suggested that, in fact, in this context, due process is not a requirement of judicial process. His suggestion was that the government can afford all the process that is due even to a U.S. citizen who might be subject to a targeted killing, simply through internal checks and balances. That a sufficiently rigorous internal deliberative process, a sufficiently vigorous internal set of checks and balances would be more than enough to satisfy whatever due process concerns these kinds of strikes might raise. That's a remarkable argument, and it's one that surprised a lot of people when it was made, and it's part of why folks are so interested in seeing the OLC memo, to see exactly how this is supported. What authority is there for this proposition? So as Amanda mentioned, Monday night we got the white paper, which is a poor man's OLC memo. It is not nearly as detailed, it is not nearly as nuanced, and as a result it actually really doesn't give us a very good sense of how these decisions are actually made. It speaks in very general terms about the relevant legal standards, and it asserts as a general matter that the government's not very well described internal deliberative process is enough to satisfy due process without ever explaining why you don't need judicial review in this context. Indeed, right, all the white paper says about judicial review is that deciding in advance of an attack on the U.S. citizen, whether that's legal or not, would be a non-justiciable political question. And if you look at this section of the white paper, it's page 10, section 2C, you won't see a whole bunch of citations for that proposition. You'll see one. So I don't want to sort of go over, I want to turn to my other colleagues, but from a due process perspective, I think this is why the white paper has stirred up so much controversy. It is entirely possible that when fully described and when publicly disclosed, the actual process the government goes through will be so rigorous and have so many checks that we might actually say, yeah, that looks pretty fair. Right, and that given the needs to protect secrecy and given the needs to protect intelligence sources and methods, that's the best we can do under the circumstances. The problem is it's impossible to actually evaluate that without seeing that rationale. And the white paper, I think, doesn't come anywhere close to going there. So I'll shut up there, but hopefully get to come back and say more about this later.
Thank you, Steve. We're going to turn to Bob, and I should mention also that we're going to give you all a chance to ask some questions at the end of the program. And in addition, for anyone who is watching a webcast, if you have questions, you can send them into humlaw, H-U-M-L-A-W, at wcl.american.edu.
Well, thank you very much. I'm not just concerned about the program that has resulted in the so-called targeted killings just of Americans. Because there's no question that if an American in an actual situation of armed conflict fights for the adversary, he is a lawful target. That's a non-brainer. It's a much larger issue that is involved here. And it is one which, quite frankly, we would not have to be discussing today. Had the Obama administration, as many have urged, including myself, had broken with the position that had been advanced by the Bush administration, the notion that the United States is involved in a new kind of armed conflict that is worldwide in scope against al-Qaeda and its so-called affiliates and associated forces, and that its top members, or operational, it changes at times depending on the memo or the litigation that's ensuing, where these people are lawful targets of attack, even in third countries with which or with whom we are not at war. Now, this position was really given legal and political cover by the Supreme Court of the United States when, in the Hamdan case, they decided that the conflict against al-Qaeda was a non-international armed conflict within the meaning of Common Article 3 to the Geneva Conventions of 1949. Now, while one can understand and certainly sympathize with Justice Stevens and the majority in the Hamdan decision, and I certainly do, that they wanted to impose some minimal rules on an otherwise lawless Bush administration in its fight against al-Qaeda, and particularly in the trial and treatment of its members who we captured, its reading, that is the court's reading of Common Article 3, is simply wrong. It's erroneous. The law of war, or international humanitarian law, recognizes two kinds of armed conflicts. International, and those are between states, such as when the United States went to war against Iraq, and non-international armed conflicts. Now, since al-Qaeda is not a state, it cannot be involved in a war with the United States, which is international in nature. But what about the second, a non-international armed conflict? Well, as understood and reflected in state practice and doctrine and in decisions of international war crimes tribunals in recent years, a non-international armed conflict requires a certain level of armed clashes between governmental armed forces and armed opposition groups, or between armed opposition groups that occur in most cases entirely within the territory of a single state, with the occasional exception of spilling over of the hostilities into a neighboring state. For example, Afghanistan, the hostilities go across the border into Pakistan. We have had examples of this in the Turkish conflict against the Kurds in southern Turkey, have occasionally gone across the border into Iraq, and in Colombia with cross-border attacks by the Colombian armed forces in at least one major case in the territory of Ecuador. So you will understand that a non-international armed conflict requires that territorial boundaries of the hostilities be defined and identified, as well as the warring parties. Now, much of the violence that has been characterized as part of the war on terror by the United States since 9/11, such as the bombings in Bali, London, Madrid, Istanbul, and Mumbai, have not been committed by a single organized armed group which in any way can be said to be a party to an armed conflict. Rather, most of these violent attacks have been committed by loosely organized networks or by individuals who merely share a common ideology. And in some cases, such as in Indonesia, the non-state actor has been involved in a non-international armed conflict with the state way before 9/11. And let me point out, in none of these countries where these terrorist acts have occurred, have the governments labeled the perpetrators combatants and charged them with violations of the laws of war. Instead, they have been held and tried as criminal suspects and tried under anti-terrorism law. Consequently, outside of the United States, you would be very hard-pressed to find a law of war expert, much less a country who accepts the notion of a global war on terror. And the President of the United States, neither the Congress of the United States nor the Supreme Court can make it so merely by the stroke of a pen. However, where the so-called putative war on terror coincides with a genuine situation of armed conflict, then we do have war rules apply, and it is perfectly appropriate to target individuals who are combatants or, as I will mention in a second, civilians under certain limited circumstances. But where there is no armed conflict, there cannot be any notion of combatants, and war rules simply do not apply. Therefore, the premeditated killings of persons in third countries without armed conflict or with whom we are not at war will most likely violate, as Hadar will probably tell you, human rights law, which employs what is known as a law enforcement paradigm, which requires strict application of rules dealing with the use of lethal force. But let's assume for a second, just a couple of points and then I'll conclude. But let's assume for a second that Bush and Obama and Stevens and so forth, and we have the wisdom, and there is such a thing as a global war against this non-state actor, and affiliated, as sometimes they say, affiliates or associated forces. If you look at the memo, they define this by way of a footnote that says that an associated force is equivalent to a co-belligerent under the law of war. How interesting. I know a co-belligerent when I see it. And for instance, the United Kingdom, France, and so forth, were co-belligerents with us against the forces of Gaddafi, just as Italy and Japan were co-belligerents with Germany in World War II. But who are these parties in this putative war on terror? As I've mentioned, many of these are groups, probably who have never had any direct conversations whatsoever with Al-Qaeda, and what they share is a common ideology, and frequently they are, like in Mali or in Yemen, at war against a government with their own political agenda. So this is very important. What is an associated force? Is it who Obama decides is going to be it, and then he's going to target you? I find that to be disturbing. The other thing is, the United States, when we go to war, we insist that our adversaries scrupulously observe the laws of war. Now, that's appropriate. But one of the fundamental tenets of the law of war is, irrespective of how you classify it, you must observe the fundamental distinction between civilians and combatants. You may only in warfare attack combatants or civilians when they are directly participating in hostilities. And therefore, the law makes a distinction between direct participation, entailing loss of immunity from attack, and indirect participation, which does not entail loss of immunity from attack. I could spend the rest of the time discussing this, and I can't. But let me say that these are life and death decisions that experts debated for 5 years. And for a memo that is going to authorize attacks against individuals in these particular circumstances to effectively not address this at all is, quite frankly, disgraceful. I would have hoped for better from this administration. I would have hoped for better from Harold Koh and Johnson and the others in this administration. But quite frankly, this is nothing but a continuation of the same flawed logic and policy that got us in trouble in the first place under the Bush administration. Thank you very much.
Thank you, Bob. Now we'll turn to Hadar.
What's always good about going after Professors Vladeck and Goldman is that you follow this wishy-washiness, where you're really not clear where they come down on things.
I was going to ask Bob how he really feels.
No, really how he feels. So in 5 minutes, because our goal here is just to really spark discussion, and we want to make sure that there is time for at least some of you in this huge room to be able to voice your questions or your comments. I want to talk just a few minutes about the human rights paradigm versus this law of war paradigm, and then also contrast the DOJ white paper, which is what we've got to go on at the moment, with the Israeli Supreme Court, High Court of Justice decision on targeted killings, which provides an interesting contrast, and quite a different contrast, to the current policy as we know it today. So, from a human rights perspective, as you've heard and as you probably already know, killing is wrong. There's a right to life and the security of person. But in armed conflict, as you've also already heard, when operating within war paradigms, international humanitarian law actually says that killing can sometimes, under specific allowable circumstances, is permissible. The practice of targeted killings through the use of drones and other devices is one that's been emerging over time, and as you've heard, has been significantly expanded by the Obama administration. But opponents of the practice say that it's in violation both of international law, that it's a form of extrajudicial killing, a vast violation of human rights, violating the Article 3 of the Universal Declaration of Human Rights, Article 6 of the ICCPR, customary international law, all kinds of forms of rights to due process, And in particular, it shifts the paradigm, as you've heard, from one where, from a human rights perspective, you may be relying on or looking at a law enforcement type paradigm where you could arrest people for criminal activities, rebels or armed groups within a certain country who may, under other circumstances, also be called terrorists, and try them outside of a kind of normalized law enforcement criminal code, and take it out of those kinds of paradigms which human rights is used to be protective of, and into a very specific world of international humanitarian law where it applies. But as you've heard from Professor Goldman, the applications of international humanitarian law and the way that it's being interpreted and the way that it's being applied in this particular circumstance seems to be quite flawed. The issue of targeted killings is one that isn't only relevant to the United States or to Israel or to Pakistan, but it's one which other countries have also grappled with, and there's a long history of targeted killings. It's taken place all over the world in a variety of contexts and conflicts over time. In 1986, America's Watch, you might have been involved in this report, released a report stating that death squads and armed forces in El Salvador had carried out over 240 targeted killings throughout 1985. There are reports from Somalia, from Rwanda, from Kosovo, from Bosnia, and all kinds of other parts of the world as well. So as we think about targeted killings in the context of how it's being operationalized today and as it's being applied through this conversation about al-Qaeda, there is a history that it builds upon. The greatest attention, though, in recent years, as we look to a comparative example, is the use of targeted killings by Israel in the occupied territories. The Israeli model, if you can call it that, for targeted killings, provides an interesting contrast to the standards or the policies outlined in the white paper. And in some ways, it makes us think even further, I'm getting there, about the vagueness of this white paper, as, again, you've heard a little bit about. The court case, which was decided finally on December 14th, 2006, in the Israeli High Court of Justice, which is an arm of the Supreme Court, ruled on targeted killings in the case of the Public Committee Against Torture versus the Government of Israel. And the petitioners who were opposed to targeted killings really fleshed out this whole law enforcement versus war model in saying that the use of targeted killings was inappropriate and was unacceptable in the context of the conflict within the occupied territories. The questions of what types of law governs, whether it was a normal law enforcement operation or IHL, was important. And the ruling that came down was one which said that targeted killings were permissible, but only under specific circumstances. It requires that such killings be attempted only when there was solid information which indicated that the target was taking a direct part in hostilities, including by planning terror attacks. That could also be construed as direct participation. When the arrest of the target would be too risky, when the likely harm to innocent civilians did not outweigh the military advantage gained by the death of the target. And finally, it required a thorough and independent investigation be carried out in the wake of every such attack. A thorough and independent investigation be carried out in the wake of every such attack. Sounds like some degree of judicial review to me. Some degree. There are key differences between what the white paper says and what this Supreme Court, what this High Court of Justice ruling in Israel does. One very key difference, which nobody has mentioned yet, is not just the judicial review aspect of it and the due process reviews aspect of it, but what is imminent threat? Because this white paper really expands and provides this incredibly flexible definition of imminence. The white paper itself, with its NBC News watermarks all over it, which is how we read it right now because they're very proud that they got it leaked.
It makes the OCR very hard.
Yeah. It says, yeah, it does. says certain, and I'm quoting, certain aspects of this legal framework require additional explication. It's good that they noticed that. First, the condition that an operational leader present an imminent threat of violent attack against the United States does not require the United States to have clear evidence that a specific attack on U.S. persons and interests will take place in the immediate future. It goes on and on and on. And it says, by its nature, therefore, the threat posed by al-Qaeda and its associated forces demands a broader concept of imminence in judging when a person continually planning terror attacks presents an imminent threat, making the use of force appropriate. In this context, imminence must incorporate considerations of the relevant window of opportunity, the possibility of reducing collateral damage to civilians, and the likelihood of heading off future disastrous attacks on Americans. It's pretty broad. It goes on and gets even broader. In Israel, and under this Israeli court ruling, the definitions of imminence talks about an attack that is going to occur. A plan is underway. It is not abstract, and there is clear evidence. Now, I'm not saying that the Israeli Supreme Court decision is the end-all, be-all. I'm not saying that it's the right criteria, and I'm certainly not saying that I think that targeted killing is a great thing to do. However, it at least provides a framework. It at least provides some safeguards. It at least provides some kind of clear criteria through which operational commanders can actually exercise their discretion with limits. This memo does not provide that at all, and in any and with just a reasonable interpretation of what the Office of Legal Counsel memo may say, you know, as one counterterrorism expert said this morning, this gives the U.S. carte blanche, and there's nothing more dangerous in operational counterterrorism than to give a commander carte blanche. So with that, I'll end and hand it over to my colleague Dan Marcus.
Thank you, Hadar. I'll give my usual introduction, which is, as a liberal Democrat, I feel like one of the more conservative people on the AU faculty.
I'm with you, brother.
One quick word on my narrow assignment, which is to tell you about Brennan and the hearings today. The hearings are going on as we speak. I did tune in for a few minutes today and did manage to hit probably the best questioning, which was by Ron Wyden. But the Republicans are just asking him about the leaks from the administration that they think helped the enemy.
Why did you disclose the white paper?
But Brennan is handling himself very well and is going to be confirmed. That's my confident prediction. And he will, believe me, well, never mind. He's not a bad guy. Whatever he did on torture, he's not a bad guy. Seriously, I think he's probably a civilizing, reasonable participant in whatever process the administration has for making these targeting decisions. Let me spend the rest of my time responding to a few of the things that my colleague said, because while I think the white paper is very inadequate and has problems with it, I think the Obama administration policy is not quite as bad as has been pictured by some of my colleagues today. Just a couple of random thoughts on that. One, I think Hadar makes a very important point about the process point and the judicial review point. But in terms of the substantive standards of the administration policy as set forth in the white paper, it seems to me they're pretty consistent with the Israeli Supreme Court decision, and the test for whether somebody, whether a U.S. citizen or not, is a legitimate target in an ongoing armed conflict doesn't seem to me to be very different. Professor Goldman makes a strong argument for the proposition that the conflict we're engaged in with al-Qaeda and associated forces, at least with respect to that part of it outside of Afghanistan and the border areas of Pakistan, is not under international law is not an armed conflict that is governed by international humanitarian law, and therefore we're not entitled to do the kinds of things that we could do under international law in an armed conflict. There's a strong argument on that point, but it's an argument that's clearly been rejected by all branches of the U.S. government. And for better or worse, this administration and the Congress are committed to the proposition that we are engaged in a war authorized by Congress against al-Qaeda and associated forces, and that in that armed conflict we are entitled to target enemy combatants who are fighting for al-Qaeda wherever they're located. Now, there's a lot of problem as a policy matter with that position too. But in other words, it's not the law of armed conflict doesn't work very well in this new kind of war. But that's what the U.S. is committed to, and I think the most important question is, given that assumption, is our current targeted killing policy, as outlined in the white paper, acceptable under international law and under U.S. constitutional law? And I think there are serious questions on that count, and they revolve mainly around U.S. constitutional law with respect to the targeting of a U.S. citizen like Anwar al-Awlaki. I can't understand why the Obama administration isn't willing to tell us more about the internal process in the executive branch for deciding whether someone can legitimately be targeted, whether he's a U.S. citizen or not, but particularly if he's a U.S. citizen who has due process rights. In one answer that I saw from Brennan today in response to a question from Wyden, I think, he said he seemed to be saying that he was prepared to say more about what the internal process within the executive branch is. And Harold Koh has assured us it's a robust process, and he wouldn't be blessing it if he hadn't peered over their shoulders and seen what they were doing in it or participated in it himself. But there's no reason why they can't tell us more. Judicial review, I think, and by the way, on judicial review, I just saw a report that Senator Feinstein, the chairman of the Senate Intelligence Committee, said in her opening statement that she's going to introduce a bill to provide for to create a special court to oversee the targeted killing programs, presumably like the FISA, the Foreign Intelligence Surveillance Court, that oversees the NSA surveillance program and electronic surveillance for foreign intelligence purposes.
Dan, do you need a job?
What?
Do you need a new job?
Not interested. It seems to me that I'm very dubious that judicial review, even post hoc, of decisions about whether to target somebody are going to be meaningful. That they couldn't be very public. I don't see that a court is going to really be able to do anything terribly useful after the guy's been targeted and killed. What might be more useful, although it's not is to do something like we do with respect to covert actions generally. Congress in 1980 or so passed a law that requires the president himself to approve any covert action by the CIA and to make findings with respect to that covert action that is justified, and to report that decision to the congressional leadership and the leaders of the Senate and House Intelligence Committees, not to get their approval, but they can squawk about it. So there are models for doing things in here that would give the public more confidence that the decisions that are being made are legitimate decisions. I've gone over my time, but so did my colleagues. I'll make a couple of additional minor corrections. One, I think you should know that while there's been a lot of criticism internationally and domestically about civilian casualties in drone attacks, the administration takes the position, and Brennan said it again today, that the amount of civilian casualties has been greatly exaggerated. Now, this may be in part a quarrel about who's a civilian and who isn't. But I wouldn't rest the major case against the drone program. There are a lot of good arguments, policy arguments, why we shouldn't be doing this. But the danger to civilians, I don't think, is one of them. Indeed, one of the advantages of the drone technology is that it's so precise in targeting that it minimizes civilian risk much more than, than bombing from airplanes or sending missiles from aircraft carriers and so on. Imminent threat. I think my colleagues are right in suggesting that's a big problem with the white paper. It says we only do this when there's an imminent threat, and then it defines imminence in a way that robs it of all reasonable meaning. The other thing I saw before I came here was a blog from our colleague Ken Anderson, who's sort of Mr. Drone. No, seriously,
because that's how he talks?
No, that's how I talk. But Professor Anderson, who really has written a tremendous amount of very thoughtful stuff on this issue, makes the point about the white paper that, hey, to the extent that the law of armed conflict applies to this, we're not limited to targeting enemy combatants who are posing imminent threats. In a war, you can go after and kill enemy combatants even if they're not trying to shoot at you at that very moment. And I'm not an expert on IHL, but I assume that there's something to that. I think that's probably, one other little thing I can't resist, Amanda, Professor Frost. When you say this, we're talking about targeted assassinations. If we were, the president would be violating U.S. law because there's an executive order that's been in effect a long time banning any U.S. officials from authorizing assassinations. The theory of the Obama administration is this is not an assassination because if you kill an enemy combatant in a war, that's not an assassination.
Well, it's not just the Obama administration. It's the Hayes-Parks memo from '88.
Yeah.
All right, so we want to make sure that we have time for your questions. So if you have questions for this panelist, and thank you all for your thoughts, this is the time to think about coming down to a microphone and asking them. And I will just also remind those who may be listening that you can send questions to humlaw@wcl.american.edu. That's HUMLAW@wcl.american.edu. Go ahead, please. Click that you do the webcast people. Green light will go.
I sort of have a two-part question, and one of them kind of pushes back on something that Professor Marcus said about the civilian casualties, and also has to do with the due process aspects of this. So regardless of any legal justification that the Obama administration makes for this coming up if they release another memo, that doesn't, any rigorous process they have doesn't really comport with the only information we have of what's going on the ground, which I'm referring to a Stanford and I think NYU law professor's study as to actually what's going on in northwest Pakistan right now. And it appears that they've created an absolute terror regime where kids are scared to go outside. People are in ambulances actually have a rule where they won't follow up on a drone attack for 6 hours because of double taps, where they actually hit aid workers. Normal tribal structures are breaking down so they can't resolve property disputes. So I guess my question is, regardless of any legal justifications that the president might have, this sort of just trust me attitude, his rigorous process, whatever Obama might be claiming, appears to have nothing to do with what's going on the ground. So that sort of goes to your commentary about the civilian.
Can I
casualties.
Is there a question mark at the end of that sentence?
Sorry, it was more of a rant. But how would you comport your commentary with what we're actually hearing on the ground? How can you reconcile that? And then to the due process aspect, the question is regardless of any rigorous process, how can we accept any rigorous process when it's not comporting with the facts we have on the ground?
You raise a very strong. I was on the panel with the Stanford kids and professor who discussed that, and the report is a very serious, thorough report. And that, because of that report, is one of the reasons there's this great disconnect. Obama administration officials are telling us that not only are the drone attacks designed to minimize civilian casualties, but in fact there have been relatively few, very few. And the Stanford report is completely to the contrary. And that's why I said there may be there's often disagreement in these things as to who was killed, whether they were al-Qaeda fighters or whether they were civilians. So that may account for part of it. But there are lots of, the impact on civilian populations, even if they're not getting killed by the drones, is a very serious problem and is a basis for arguments that whatever benefits we're getting out of this targeted killing program for killing a few al-Qaeda senior people, those benefits are outweighed by the fact that we're pissing off half the population of the world, or we're making enemies of the Pakistani people or the Yemeni people, and we shouldn't be doing that. It's not worth it. But that's a policy argument and a serious one.
And Nick, I'll just say briefly on the due process point. I mean, the problem simply put is that this administration has not changed its position from any prior administration that the due process clause doesn't protect non-citizens outside the United States. And so, part of why there's been so much focus on Anwar al-Awlaki is not just because he's a U.S. citizen, but because his is the case where there would be the strongest possible argument that the government had acted unlawfully. And even there, right, we don't know what the argument is because we haven't seen the full memo. And just to sort of piggyback on something that Hadar was saying, I mean, I think, and this is perhaps one place where we disagree, I suspect the actual 56-page OLC memo is incredibly nuanced and detailed and rigorous and precise. And that if we actually could see it, we'd probably be a lot less bothered by the vagueness and the open-endedness of the definition of imminence, for example. But the problem is that I only suspect that.
Yeah.
I mean, I hope you're right. There's nothing to lead us to believe that.
Well, let me just say, this is now going to be scrutinized by the Special Rapporteur on Human Rights and Terrorism, who's a very eminent Queen's Counsel, Ben Emerson from Matrix Chambers in London, who currently holds that position. And I expect that we're going to see a thorough study. The other thing that, particularly for the students, that I would ask you to think about is international law is made by a process of claim and counterclaim. To the extent that we arrogate to ourselves the right to be able to do this, we give rise to other states. Who are we to tell Putin, who feels threatened by 3 women who call themselves Pussy Riot, and has them prosecuted and put away, that this guy is going to be able, if he has domestic enemies who he thinks are in Kazakhstan or Chechens who pose a threat or they're operational, or they may be in London or they may be elsewhere, or any other government. We are helping to open, quite frankly, a Pandora's box. And if we can do it, then other states can make a claim to do it. And this is a very, very dangerous situation.
And I think that there's precedent for that. I mean, we saw that right after 9/11. We saw that with cut-and-paste versions of the Patriot Act in Kenya, in Uzbekistan, in Russia, using it against Chechnya. And so I think that Bob's comment is very much in place.
Let me just back up a second. I mean, so I'm gonna align myself with one thing that Professor Marcus said, which is feeling sometimes like a conservative, at least here. And in my family, too. So I I think we're skipping one very important feature of both the U.S. and international law chunk of this discussion, which is that the Obama administration has always maintained, rather steadfastly so, that one of the critical criteria to these strikes is the infeasibility of any other means of incapacitating the individual in question. That's part of why all of the drone strikes are in northwest Pakistan, in northern Yemen, in parts of Somalia. It's because these are places where there is no functioning civil authority whom we can ask to arrest these individuals. And so just, I understand the rhetoric and the rhetorical pull of saying if we can do it, then China will do it, and then Russia will do it. I think, the administration has tried really hard to be careful. That's why it is such a shame that they won't actually release to the public the evidence of just how careful and how nuanced they've been.
Okay, let's take another question from the audience, just because otherwise
we won't.
We won't. This gentleman over here.
Is it on?
No. On the top.
Yes. Okay.
There you go.
All right. My question is for Professors Vladeck and Marcus. If Professor Vladeck is correct in thinking that this memo and that this process is, in fact, an adequate substitute and is judicially reviewed and found to be so, then what is the value in the post hoc review that Professor Marcus spoke of if it's not actually being applied in a manner that is adequate, that is an adequate substitute for due process?
So, Gary, are you asking why post hoc review would have an effect if there was in fact a lack of process on the front end?
Exactly. Like Professor Marcus said that there is value in this post hoc review, and I'm asking what that value is.
So I guess okay. I see the question. So I think it's a very fair point, right? If the target of the attack is already dead, what is judicial review after the fact going to accomplish? And I think the short version is, as hopefully most of us have learned in law school, this is the whole purpose of damages, right? The damages regimes exist to account for the fact that sometimes we can't remedy legal wrongs until after they happen. And the purpose here is not so much to recompense the victims of the potential illegality, so much as to create a deterrent on future governmental conduct, right? So much as to ensure that the government actually knows that if it crosses the line, wherever it is, something bad's going to happen. So I think, the value of post hoc review is not necessarily in making whole what can't be made whole, but rather is in making sure the government thinks that there's someone looking over their shoulder.
Actually, my point, which I probably didn't make very clearly, the enhanced internal process, maybe involving reports to Congress and presidential findings, that I was suggesting was a not a post hoc review. It was a pre-decision process, a pre-drone attack process, just the way we do for covert action.
Although some covert actions can only have to be reported to the gang of 8 after they happen.
That's only if there's an emergency that prevents it beforehand, and it's
imminence, lack of feasible alternatives.
Yeah. But in any event, I'm dubious about a post hoc judicial damages remedy really having much of a deterrent effect. There are a lot of, for one thing, our courts haven't been terribly receptive so far in the war on terror on existing constitutional rights litigation under Bivens. It's a problem. But the courts, I don't think you can count on the courts. I'd much rather see us insist on a more rigorous and disclosed so the public can understand it and have confidence or not have confidence, executive branch congressional reporting process. I think the other thing that would be useful to do, and Al-Awlaki seems to me the perfect case to do it. The guy's been killed, he's dead, and here's the case involving a U.S. citizen that is the center of this controversy, and why the administration can't at this point give us a summary of the facts that justified classifying him as a senior al-Qaeda official planning attacks on the United States. I don't understand.
One word, Yemen. The theory behind
embarrassing to Yemen?
the theory behind why the OLC memo is still classified has nothing to do with what we knew about Al-Awlaki and everything to do with our relationship with Yemen and the extent to which we won't publicly acknowledge that we have one. I mean, I think that's a big part of this.
Yeah.
Okay, so let's take another question from the audience.
Professor, thank you for coming, by the way. Professor Vladeck, you just mentioned something I thought, I wish was in the memo, and that is not this global view, but a view that, look, we're not fighting, the United States is not fighting one armed conflict, but it's fighting five. It's fighting one in Afghanistan, Pakistan, there's an armed conflict in Yemen, and so the multiple NIAC view. And I just would like to have the panel's view on that. And the second question is the question of what some have called the robust self-defense view. And when you mentioned the Hayes-Parks memo, where Professor Parks mentions in capture or kill operations in peacetime, it's the same as in wartime. And I'm just curious why this white paper doesn't include any state practice, why it doesn't include some of these, these old views that, against the Barbary pirates, against Petrovia, and so forth. And so if I could have the panel's view on that, I'd really appreciate it. Thanks.
On a couple of things, and again, in 5-10 minutes, you can't deal with all the nuances. And I certainly
or 16 pages.
Well,
And you have 4 minutes.
I didn't realize I was with so many comedians today. They're
Have we met?
This is like being with Jack Benny. Look. When you deal with these individual situations and so forth, as I said, to the extent that the situation, you call it the global war on terror, and it coincides with real armed conflict, there's no problem. You can target combatants. You can target civilians who directly participate in hostilities. There is a cross-border armed conflict today between Afghanistan and Pakistan. This is why I had no problem with the targeting of bin Laden. Al-Qaeda is a party to that ongoing non-international armed conflict. Secondly, if Yemen, as they have done, or if Mali, as they asked France, and they said, bring your armed forces here, we cannot put this rebellion down on our own. We have these terrorists we have to deal with, and they authorize us to do so, we become a party to an existing armed conflict, and again, armed conflict rules apply. So it doesn't mean you have to look at each of these situations on their particular facts and you figure out the other legal regime, the appropriate legal regime. It does not mean in all cases, because you're operating under a law enforcement model, that you cannot use deadly force. You can. In the case of Yemen before, they sought, and we told them there was this fellow here. And Yemen sent out their police and military to arrest him, and I think 30 or 40 of them were just decimated and so forth. And they requested and authorized the United States effectively to capture or kill. And the only feasible alternative was to kill. There are circumstances, therefore, when you can do it. And so I think, however, is rather than taking this kind of global view that you're involved in anywhere in the world and you can do this and then you don't make the necessary distinctions, you can do many things by adhering to the law, but apply the appropriate model and so forth. Because if you don't apply that model, you can end up doing an awful lot of damage. And as I said, it creates a snowball effect in terms of other states saying, we can do the same thing if you can do it.
I'm not an expert on criminal law, but I didn't think just because you think someone's committed a crime, you can go kill him.
That's not what I said.
I realize that. You said if Yemen, but if there's no armed conflict in Yemen, how can Yemen authorize us to kill Anwar al-Awlaki?
First of all, the situation at the appropriate time, there has been non-international armed conflict that existed there. Secondly, I have no problem where you operate, if you see, for instance, just because your military are operating overseas and so forth, does not mean that your military always is going to be operating under military or war rules. They're going to be operating, for instance, when we have been out in the Somalia, in the waters and so forth, we've used special forces that have attempted to capture and so forth the pirates, and where they haven't been able to, they have been able to use lethal force. There are situations in law enforcement that are recognized, like in hostage situations and so forth, where you are able to use lethal force. And what I'm saying is you can extrapolate those kinds of rules, Dan, in a situation in where it is not feasible to capture and so forth. You can do it. But you tell the truth. We are doing this. We are applying this model and so forth. We tried to ask the government. The government is unwilling or unable and so forth, and this is what we're doing. So that's the point.
Yes, one more question from the. This is our last question from the audience.
Hello. I was wondering more from the perspective of the international community, as we have more advances and changes in the way we're killing people, essentially. What is it that the international community can do to hold countries like the U.S. accountable, especially a country like the U.S. that usually only listens to themselves? And I know we're not party to the Rome Statute and other mechanisms that hold other countries accountable, but what, going forward in the changing technology, can the international human rights and humanitarian law community change to address that?
It's a fantastic question. I mean, I think I'll start, and then Hadar can correct me. I think, one of the really important things to keep in mind here is that the strikes that we are undertaking in Pakistan and Yemen and to a certain degree in Somalia, you never hear any noise about them being violations of those countries' sovereignty. And part of that is because, well, you hear noise about it. You never hear noise from the... Okay. You hear it in Pakistan. So let me try this again. You hear noise about it, and then everyone says, but very quietly, these strikes are actually being done with the consent of those governments. They just can't acknowledge it. Is that better? And so Aaron, to answer your question, I think a big part of it is you need less sort of complacency on the part of the countries whose territory is literally being invaded for these strikes to occur in, right? You need more than just sort of these pro forma, woe is us. You need them to actually say, stop launching drone strikes on our territory and mean it. Before you can actually, I think, see any kind of more multilateral consensus, multilateral push toward stopping the practice. I think the other problem is, the UN has been fairly supportive of anti-terrorism, counterterrorism efforts, and it's been pretty hard to get anything limiting those powers through the Security Council, partly because of who's on the Security Council. So, Aaron, I think it's unlikely that the pressure is going to come from without. I think it's much more like it's going to come from within, and I think that's what needs to happen.
All right. So since we're a few minutes over, I was going to say let's have Hadar have the last word here.
Oh my God, that's so awesome. That never happens.
It's called a filibuster.
I think that there are lots of mechanisms that are set up, and Professor Goldman talked about the independent expert on human rights and terrorism. There's a working group on extrajudicial killings. There is an upcoming review of the United States by the Human Rights Committee, which oversees the International Covenant on Civil and Political Rights. They've taken up issues of extraterritorial jurisdiction for certain aspects of the ICCPR. It's a bone of contention with the United States, of course, that doesn't accept that that's applicable. However, there are certain mechanisms that are in place that can be and will certainly be taking a look at this and certainly be weighing in. But on the ground, those people in Pakistan, those people in Yemen, those folks in Afghanistan, some of whom may be watching right now, also have the ability to document what's going on, using cell phone technology to take videos of the after effects of a drone strike, being able to actually show the impact on societies, which I think can, if leveraged correctly, and utilizing these various mechanisms both in the international community and the fact that people from anywhere in the world could send their questions in to a forum like this if they know about it and if they're awake at this hour. I think, if utilized correctly, can create some sort of base of public pressure. The problem is that this administration, similar to the previous administration, and it really pains me to say that, isn't really responding, isn't really paying attention. Maybe they're paying attention, but they're certainly not reacting to it. And so it's very disappointing, as someone who works on both human rights and humanitarian law issues, to look at the response, where we have excellent people in place, like Harold Koh, the legal advisor of the State Department, who is creating these kinds of shields or legal constructs, which I think many people would disagree with, and creating a veil of secrecy around what the justifications are. So I hope that our discussion today helps to point out what some of those problematic issues are, and helps us to create a conversation both within our community at the law school and more broadly to try to really urge a certain degree of transparency and a certain degree of understanding about what the justification is for this and where some of the issues of great dispute are. So I would end with that and say thank you.
Thank you, panelists. Thank you, audience, for your attention.
One last point. I'd like to thank the people who were watching on webcast. We were told that over 30 people were watching from various parts around the world, and so we thank you for joining us as well.
And we'll stick around if you have questions you want to ask up here.
Thank you.